the issuing bank.
Yes, the one person.
11.1 says all payments for the issuance of the bond shall be accepted in Indian rupees through demand draft or check or through electronic clearing system or direct debit to the buyer's account.
Yes. So it will
payment
have
is
to be
made
through
check or
banking
draft
channel.
shall
No,
be
the
drawn in
purpose
favor
is
of the
this.
issuing bank, and therefore the issuing bank has all the data.
No. It would come, Lord. Therefore, it would come. The only person who would first know my name and is the person to whom I give KYC. Then KYC is sealed cover is maintained elsewhere. But it comes. The details of donor, i.e. the KYC details are put in a sealed at the end of each tranche, because within 15 days, many people purchases multiple bonds. But I may purchase 10 bonds worth 10 lakhs of rupees. Tranches by the designated branch and sent in a sealed covered form to the SBI main branch, Mumbai main branch, where it remains sealed till the contingency under clause 7(4) arises. So Guwahati, where purchases are made, or Trivandrum, where purchases are made, will send it in a sealed form to Bombay. So far as the redemption of these bonds by the political parties is concerned, each party can deposit such bond only in their designated account. In account details of the political party also, only the amount of the bond will be reflected, as the bond does not contain the name of either purchaser, donor, or the political party. The political parties would have one designated account in one branch out of the designated branches of SBI, in which only the redemption of electoral bond is permissible. So bond may have been purchased from Chennai, but will be redeemed or can be redeemed in Calcutta. However, the political party can present the bond for redemption in any of the designated branches, which will credit the amount only in the main designated branch. They can go to Jaipur and say that this is my bond. The money would be transferred without anybody's name to the designated account wherever it is maintained, one designated account. At the time of redemption, the original bond, the pay-in slip would be storage in a sealed cover and sent to SBI Mumbai main branch. Both the sealed covers cannot be opened either together or at different times except under the contingency under clause 7(4) arises. In the event of contingency under clause 7(4) arising, it would be very difficult to trace out that even after that, Malot, kindly see this. It's not as if we open the cover and match it. Trace out the details of the purchaser of the bond, as such purchaser may have purchased several bonds from several designated branches in different tranches. In other words, several sealed covers may have to be opened and examined. 2. So far as details of redemption details are concerned, they are stored in the Global Information Technology Center of SBI, which stores the data in a digital format. In case the link between the donee and the donor is required to be established in terms of clause 7(4), it would require a detailed and in-depth tracing out of information from two different information silos of donors and donees. The said exercise is not automated and cannot be carried out in a linear fashion and requires a scanning of different databases which are designed without maintaining interlinkages. Therefore, the process of issuance and redemption of electoral bond and data generated therewith is not maintained in a central database, and the datasheets are not populated and tallied at one end. There exists no direct linkages, and completely separate information silos are stored under separate heads with separate departments. So I'll have to ask several people to collude with me if I want to get the information. Because, Lord, I have not given that, but this center, Lord, Global Information Technology Center also, as I was not explained, I was also not explained in detail, and nor did I insist. But they also have 3-4 layers. It goes, the request with the court order goes to one, he will open, then it goes at a second layer, then he opens, and everything is digitized, leaving the footprints. And therefore, my lord, to satisfy your lordship's conscience, I say, that please criminalize if there is anybody who breaches this system. If there is a genuine public interest in the disclosure, you go to the court, you have 7 for remedy. But merely for your curiosity, you cannot invade somebody's privacy if that privacy ultimately serves larger public interests. My lord, that's the submission which I have made. My lord, I have quoted the relevant paragraph. I am not, my lord, reading it. Your lordships are aware. Lord, please come to page. I'm sorry.
Yes.
Page 39. I am just skipping through, my lord, rest.
Yes.
My lord, not that I'm giving up, my lord. Maybe treated as read.
Yes.
Para 95. In the matter of Puttaswamy, this honorable Justice, it should be Justice Puttaswamy, this honorable court discussed the validity of section 33 of the Aadhaar Act, which provided for disclosure of information including identity. I'm sorry. Lord, I was on 95 reading Puttaswamy, second para, 95 second para. It is submitted that while upholding section 33, this honorable court, however, added a layer of safeguard as per which such information may be shared only upon an order being passed by the judge of a high court. Now, your lordships respected the privacy, but in public interest, if lordship says that if it is required, then of course with the order of the high court. So it's not, my lord, as if it's an afterthought which I am suggesting to your lordships. It's already there in my written submissions, which shows, my lord, that the intention is not that there is no level playing field. Government, whichever is the party in power, knows about it, and the rest of them do not know. Nobody should know. That incentivizes clean money coming into the system. Then your lordships, my lord, kindly skip the rest and, my lord, come to, my lord, I have quoted, my lord, FAQs which are relevant, my lord, but broadly I have indicated, my lord, what are those, my lord, FAQs. Please come to, my lord. But this I have already argued. I will not, my lord, bother your lordships. Please come to page 48. My lord, here, my lord, I would respectfully seek permission to read only few paragraphs of the judgments, my lord, because your lordships had a valid concern that in some cases it can be quid pro quo, in some cases it can be misused also. Yes. Nobody says that it cannot be. Any system can be misused. There can never be a system which is so foolproof which can never be misused.
You are reading the Shirur Math case?
Yes, my lord. Lakshmindra Tirth, my lord, the Shirur Math, my lord. Kindly see the last 3 lines which are bold and highlighted, my lord. For your lordship's convenience, my lord, I have done this. I don't wish to read the whole. The saving provision contained in section 91 of the Act makes the position quite clear. An apprehension that powers conferred by this section may be abused in individual cases does not make the provision itself bad or invalid in law. Now, this is, your lordships are aware, my lord, 7 judges case. 7 judges judge. It can, my lord, in Indian ingenuity is, my lord, popular around the globe. And general human ingenuity, my lord, everywhere this is happening. Then, my lord, please see 117. Similarly, in collector of customs versus so-and-so, this court observed, the possibility of abuse of a statute otherwise valid does not import to it an event of invalidity. Further, in state of Rajasthan, it was said that it must be remembered. Well, these are very well put, therefore I am tempted to read. It must be remembered that merely because power may sometimes be abused, it is no ground for denying the exercise of power. The wisdom of man has not yet been able to conceive of a government with power sufficient to answer all its legitimate needs and at the same time incapable of mischief. There can never be a system. We have started, we have begun, and as I pointed out, the beginning is giving us fruits. Digitized money, my lord, is bringing clean money into the system. I have given the figures, my lord, of payment made by digital mode. Then, my lord, Keshwanand Bharti, in exercising the power of judicial review, the courts cannot be oblivious of practical needs of the government. The door has to be left open for trial and error. Constitutional law, like other mortal contrivances, has to take some chances. Opportunity must be allowed for vindicating reasonable belief by experience. Look, the government, which consists of all politicians, the parliament consisting of all people in politics, my lord, they discussed this threadbare and found that there may be some lacunas in the system, but this is under the circumstances the best system. My lord, that trial and error, my lord, the government is entitled to. My lord, then, my lord, I am not reading Mafatlal, but please, my lord, come to, my lord, I am not reading A.K. Roy also, please treat it as read. Please come to, my lord, PUCL also, my lord, is on the same lines, my lord, therefore there is no point in duplicating, my lord. Then, my lord, I have pointed out, right, my lord, legitimate state interest. So your lordships would always balance. I have argued this, my lord, I will not take your lordship's time further. But the legitimate state interest is linked to public interest. So you have the right to information, no denial. But you have the information which company purchased how many bonds, and you have the information in public domain which party got how many electoral bonds. If anything beyond that is encouraging cash economy to enhance, that your lordships can balance, and that would be in the legitimate state's interest. That public interest would be of paramount consideration when your lordships examine this, my lord. Lord, please see para 130.